For anyone contemplating incorporating a Canadian federal corporation or currently operating a Canadian federal corporation, they need to be conscious about the new individuals with significant control reporting requirement. The most current enactment of Corporations Canada to require federal corporations, which are incorporated under the Canada Business Corporations Act, to file information on individuals with significant control will make this avenue of incorporation ever more unpopular. Because when any business, foreign or domestic, contemplates incorporating in Canada, they will need to consider this added disclosure requirement, which may not sit well with the individuals who are necessitated to disclose this personal information, especially in light of the other differentiating factors of federal corporations that makes them increasingly less attractive as compared to most provincial incorporations in Canada. An individual with significant control is someone who owns or controls a CBCA federal corporation where that individual owns, controls, or directs 25% or more of its shares individually, jointly, or in concert with one or more individuals, has control in fact over the corporation without owning any shares, or meets a combination of any of these factors. What are the particulars of filing and updating information on individuals with significant control that is mandated by Corporations Canada for federal corporations? There is both information that will be made publicly available on Corporations Canada's website, together with information that the government intends to privately retain, that will be required to be filed and promptly updated as to individuals with significant control. The following information on each individual with significant control is to be filed with Corporations Canada and is made publicly available on Corporations Canada's website. Full legal name, date the individual became an individual with significant control and ceased to be an individual with significant control as applicable. Description of the individual with significant control. Residential address will be made public if no address for service is provided. Address for service if one is provided. The following information on each individual with significant control is also required to be filed with Corporations Canada, although it does not form part of the publicly available information on Corporation Canada's website. Date of birth, country or countries of citizenship, country or countries where the individual with significant control is considered a resident for tax purposes, residential address if an address for service is provided. Corporations Canada does note that information about an individual with significant control who is less than 18 years of age will not be made available to the public. The information will automatically be made publicly available when the individual turns 18 years old. Yet, how many individuals under 18 years of age are really in a control position? Given that this disclosure is in all likelihood intended to assist Revenue Canada in identifying improper tax planning and other illicit business activities. This is discernible from their further statement that law enforcement and the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, will have access to individuals with significant control information whether or not the information is made public. Individual with significant control information needs to be filled out with Corporations Canada at the following times: annually, at the same time as filing your annual return, within 15 days of a change in your individuals with significant control register, and upon incorporation or within 30 days of the date of certificate of amalgamation or the certificate of continuance. In turn, the consequences of not filing and updating a federal corporation's individuals with significant control information with Corporations Canada can be quite severe. A corporation that does not file its individuals with significant control information with Corporations Canada may be subject to administrative and criminal sanctions, including a certificate of Compliance may be refused. The corporation may be administratively dissolved if it has not filed its individuals with significant control information upon incorporation or within 30 days of the date on the certificate of amalgamation or on the certificate of continuance. The corporation may be administratively dissolved for not filing its individuals with significant control information along with its annual return. The corporation may be found guilty of an offense and liable on summary conviction to a fine not exceeding $100,000. The perceived added demand associated with making such information available as to individuals with significant control, together with other considerations we have previously raised about federal corporations, when compared to provincial corporations, definitely reduces their level of business attraction. One can easily speculate as to how this added reporting requirement would make such incorporations of a federal corporation far less attractive, especially with foreign businesses seeking to incorporate and engage in increased Canadian business. Whether corporate ownership is foreign or domestic, these added considerations need to be properly accounted for prior to proceeding with incorporation in Canada, such that it is advisable to engage with knowledgeable corporate legal counsel to assess and scrutinize one's business approach. For an experienced corporate lawyer for incorporations and other corporate law matters, contact our law firm today. Thank you.